Good morning, everybody. So this morning we have Susan Walker, who is of counsel to the firm of McAfee and Taft. Ms. Walker is a graduate of the University of Oklahoma College of Law, whose practice is focused primarily on issues affecting the healthcare industry. She's a member of the firm's dedicated HIPAA compliance and health privacy team, and regularly counsels providers of their obligations under federal and state law to ensure the privacy and security of protected health information. And we also have Ms. Mary Homan, who currently serves as Director of the Ethics for the Mercy West Communities. She earned her Master of Science in Healthcare Ethics from Creighton University and is responsible for providing leadership for the Clinical Ethics Service for the 12 hospitals in the Mercy West service area.
So there's a couple things that we want to cover today. Is we want to talk about the Mercy approach to end-of-life care. And we believe that we have a pretty distinct approach to how we do things. We also want to talk about the shared decision-making approach that is the responsibility of the clinician with the family, with the patient, with other surrogate decision makers. And we also want to help you understand when and how to access your ethics committee, which is actually a pretty underutilized resource here, but can get you out of a lot of trouble before you have to call somebody like Susan. Susan's very great to work with, but we can help mitigate some of these things. So some of what we also want to talk about is what is our particular concerns with regards to life-sustaining treatment. So this is actually Dr. Cook's slide. I just want to tell you all this because it has our very favorite word on this slide. Can anybody guess what the word is? Those of you who are working on her service. It's that word futility. Futility is one of the words that you need to eliminate from your vocabulary because futility means that I have given up on you. It means to a family that you no longer want to advocate for your patient. Now, in a clinical sense, there are times when we reach our clinical end where dialysis isn't working, where someone cannot be weaned from the vent, where there is no other next step. But that's when we need to evaluate what are the benefits and what are the burdens of a particular treatment. So instead of using the language of futility or quality of life, instead we want to look at what is the benefit and what is the burden of a particular treatment. Your responsibility in that is giving the most accurate clinical information to that patient, to their surrogate, to families who are involved, but also giving them the moral information so that they can make an informed decision. That they need to know, how much will this cost? What will be the burden to my family to take care of this person? Is there a next step? So working tightly with your case management team to actually see if a family says do everything, is everything a real option? When a family says do everything, do you think that they mean labs every 4 hours? Do you think they mean antibiotics? Do you think they mean continuous renal replacement therapy? Families don't think about those things. Patients don't think about those things. Even you all who may, if you have done your advance directive, probably don't list out in 72 hours. That's as long as I want to be on the vent. And at 72 hours, you bring in a pulmonologist and you do a weaning trial. We don't list those things like that, but we have this huge expectation of our patients and the people that help them make decisions that they, in fact, understand what everything or nothing or somewhere in between actually means. We want to shape our conversation in terms of an end-of-life theology, where we have a duty to preserve life, but that duty is not absolute. So you've probably had folks who say, keep me alive forever. I don't care what state I'm in, just keep me alive forever. When someone says that, what are they actually saying? I'm afraid to die. I'm afraid of the unknown. I haven't made my peace with other people. That's why people say, do everything, or that somewhat vitalist mentality. So our task is to care even when we can't cure. What I find most interesting is because of you all, your training looks at the more holistic understanding of patients. So how do we help manage symptoms? How do we have these crucial conversations so that people understand we have, in fact, done everything, but perhaps it is time to transition to a different realm of care? When we have that conversation, it is about withholding and withdrawing life-sustaining treatment. I have a slide up here because a lot of times we take for granted the language. Withholding, not beginning a particular level of care. Withdrawing, removing or transitioning from a particular level of care. They are morally equivalent. But for many patients and for many families, there is a distinction between taking something away from somebody that causes their demise and not starting something. So in some ways, I don't know what I didn't start. But I do know that if I take the vent off Grandma, Grandma just died. And so when you talk with families, it's important that you are able to reassure them that these are the same and that they are not, in fact, causing the demise of that patient. You know that if you take someone off the vent and they're not able to breathe over the vent, they're going to expire. But your intention is not, and it shouldn't be, there is a law against that, and Susan will talk to you about it, that we can't intentionally cause someone's death, even if they say, I don't want to live like this anymore. A patient could say to you, I don't want to live like this anymore, and you would say, do the burdens of this particular treatment outweigh the benefits? If they say, my life is so burdensome, I no longer want to live, you still could remove the ventilator or excessively burdensome treatment because your intention is to remedy that burdensome treatment, as distinct from assisting in their demise. I most often get this question actually from neurology, where neurologists are really concerned with patients who have that just bad enough stroke, where you're going to live forever in a nursing home, and they're just thinking, I wish you would have left me on the kitchen floor. That is a moral struggle for that physician as much as it is a struggle for that patient and for their loved ones, because they will say, I never wanted to live like this. This isn't what I intended. This isn't what I wanted. And the way that we help people identify what they want, in fact, is because we have this 1991 Patient Self-Determination Act. This came up a lot because of the Quinlan case and a number of other cases whereby person said, I have the right to make decisions about my health care, and we, as a medical community, have the responsibility to honor those to the extent possible. Briefly, I just want to talk to you about the types of advanced care planning documents. So we have 3 pieces, and Susan's going to talk a little bit more in depthly about what those implications are for you all in practice, as well as when we're actually, if it's Chaplain Steve that's going in and helping patients fill out that advance directive, what that means. So there's essentially 3 different kinds of advanced care planning documents. The living will lays out what I do or don't want. So my living will, interestingly enough, says that I want my dogs at the hospital. And I pretty much told the security guys, I don't care what it takes. My sisters are going to bring my dogs to the hospital. Other people may have things that say, I only want to be on dialysis for 72 hours. More likely, they're going to follow kind of the traditional model that the Oklahoma statute lays out. Some people designate a healthcare proxy. Healthcare proxy, healthcare durable power of attorney for healthcare decision-making, legal representative. Those are all somewhat interchangeable terms to demonstrate that someone has executed a document, witnessed, that says someone else can make decisions when I have been declared incapacitated by my clinician. And then the third document is that do not resuscitate. And in Oklahoma, we have a community DNR consent form. And I'll talk about that later on in the presentation. One thing I'd also like to point out is about decisional capacity. Sometimes we use an erroneous language of saying a patient is incompetent. The only person who can declare a patient incompetent is a judge. It is based on your all's medical opinion that someone has not been able to consistently make decisions, cannot participate. So we like to use the idea of capacity. So if someone is sedated, they're on propofol, they're in and out of it, do you think that they have capacity to make healthcare decisions? No, not really. But what if they have a really high tolerance to that? What if they have some addiction problems and it does nothing to them? It's different. And so that's where your professional expertise and why we kind of delineated these different categories between clearly incapacitated, you are unconscious, we can't wake you up at all, to the prospects for enhancing capacity. Now the trick in all of this is you're going to have family members who are lurking. They are waiting for that 1 minute when someone's going to wake up and be totally alert, and then they're going to slide all of this legal paperwork onto the tray and say, you need to sign all of this. And your bedside nurse is going to stand there and go, no, they don't really have capacity. And the family said, no, you just said they're alert and oriented times 4. Is an alert and oriented times 4 the same as capacity? So I had a patient who was supposed to go down for some sort of GI diagnostics. And she gets down there, she tells the nurse in GI, I don't want this. And I don't want it because I don't like the idea of a camera being inserted where you're going to put that camera. And the nurse says, okay, you don't want that, send her back up to the floor. Gets to the floor and the family is furious. The family says she needs this. She doesn't know. She thinks that it's like 1954. She doesn't actually understand what's going on. And so I get consulted and I go in and I visit with her and I go to sit on the side of her bed. And she said, don't sit there. And I said, oh, are you in pain? Is this disruptive? Am I invading your space? And she said, no, you'll sit on the baby. She is over the age of childbearing, and we were not in a maternity ward. And I said, oh, the baby. What baby? And she said, well, my baby. I just got him down for a nap. I said, oh, okay, well, we'll talk really quietly. So tell me what's going on. Where were you earlier this morning? They wanted to stick a camera up my butt. Okay, that is true. That is where we were this morning. And she said, but I didn't want that. And I said, why didn't you want that? And she said, I don't really want to know why I'm sick. And I said, okay, that's interesting. But her family's like, but don't you understand? She thinks there's a baby in the bed. But what she was going through was much more something triggered past events. And she was living part in the now and part in the then. But she could clearly articulate why she didn't want this procedure. And even when we said, your children want you to have this because they're concerned, and she said, I'm a grown woman. I can make my decisions. And so the clinical team had to figure out, how does that weigh into what the next steps were? Or does it at all? Should it? Those are particular questions. I'm going to turn it over to Susan, who's going to talk to you a little bit more in-depthly about the Oklahoma Advanced Directive Act and what the implications are for you in practice.
All right. The Oklahoma Advanced Directive Act is the most clear-cut way for a patient to express sort of unequivocally what they want to have happen with life-ending decisions. Unfortunately, many people don't have these, and that's where the gray area comes in. The Advanced Directive Act allows a patient to make decisions regarding life-sustaining treatment as long as the patient is able to do so. And again, piggybacking on what Mary said, the law assumes that people are competent to make their own medical decisions unless they have been determined by a court to be incompetent. Whether or not they have the capacity at any given moment is a fluctuating standard that you all are going to have to work to help determine. In the introduction of the Advance Directive Act, it says if a person is incapable of making an informed decision regarding their health care, then they direct their health care providers to follow their written instructions. So the test is if they are incapable of making an informed decision. Two physicians must determine whether they're capable of making an informed decision. And the way the law is set up and the way all these laws are set up, that's the attending physician of record plus one other physician. So the attending has to be part of the decision-making process, and these things all have to be recorded in the medical record. An advance directive becomes operative when it is communicated to the attending physician and when the patient actually becomes incapable of making an informed decision. Uh-oh. What'd I do? Sorry, guys. This one? Okay. There we go. So there's two parts to an advance directive. The first part is what's called a living will. It contains instructions for end-of-life care. But a living will does not cover every single healthcare decision. It covers specific healthcare decisions in specific situations, and we'll get to that in the next slide. And Mary will talk to you a little bit more about the fact that Mercy will honor an advance directive to the extent permitted by law and according to the Catholic directives. The laws are a framework for decision making. So that's why I'm here. They wanted me to come and give you an overview of the different Oklahoma laws that may apply in any one given situation. But within that framework, there are a lot of other decisions that Mary's going to talk to you about. The second part of an advance directive is the naming of a health care proxy. It names a decision maker to speak on the patient's behalf if, in the opinion of the two physicians, the patient is either persistently unconscious, incompetent, or unable to communicate. So there are two different times when the two-physician decision comes into play under an advance directive. The first one is the person capable of making their own decisions? The second one is the proxy may make the decision if the person is unable to communicate, persistently unconscious, or incompetent. Typically, the proxy is obligated to make decisions as the patient has already set forth. They have to make decisions according to the known intentions of the declarant. And all of the Oklahoma laws are structured in order to allow for a person's wishes to be followed. They are not constructed to give people the ability to make decisions as to what they think ought to happen. They are structured to give people the ability to determine what the patient wanted to have happen. And that's why this document is so useful, is because the patient has already put into writing what their decision is. If the patient's decisions are not sufficient, then the proxy can use the proxy's reasonable judgment regarding what the values of the patient were and what the patient's wishes would have been. So a living will gives you instructions in three situations. And again, each of these situations has to be documented in the medical record by the attending physician plus one other physician. Number one, the patient suffers from a terminal condition, incurable, irreversible, and death will result in 6 months even with life-sustaining treatment. The second is the patient is persistently unconscious. Thought and awareness of self and environment are absent, and this is irreversible. Number three is an end-stage condition. Injury, disease, or illness, severe and permanent deterioration, incompetency, and complete physical dependency for which medical treatment would be medically ineffective. So you have the advance directive will set out these 3 conditions. And then it gives the patient 3 choices. Either the patient chooses that they want no life-sustaining treatment except for artificial hydration and nutrition. They want no life-sustaining treatment including artificial hydration and nutrition. Or they want life-sustaining treatment and artificial hydration and nutrition. And now I'm going to let Mary. Okay. And to piggyback on what Mary said as well, there is a space on the form where people can add their own instructions. So you've got to take every form and read it and ensure that you are following any particular instructions. She wants to have her dogs. I want to have all 3 of my children involved in the decision-making process, even though one of them is named as the healthcare proxy. You know, you have as many individual iterations of that as people want to express. There is also a specific law called the Artificial Nutrition and Hydration for Incompetent Patients Act. Mary, do you want to talk about these ethical? Oh, you're going to come back to it? Okay. So, Nutrition and Hydration Act says that it is presumed that every incompetent patient has directed the healthcare provider to provide him with hydration and nutrition to a degree that is sufficient to sustain life. So if the person has not executed a living will and expressed a different opinion, then this is the law. They are presumed to want artificial hydration and nutrition. There are 5 exceptions, and the law clearly states that no one has authority to make this decision except under these 5 exceptions. The first one is that the attending physician knows that the patient previously stated no artificial hydration and nutrition. In other words, the patient told the attending physician. The physician has had this conversation with the patient. Number 2, a court has ruled that the patient previously stated no hydration and nutrition. Again, it's not the court ruling that everyone agrees that it should be withdrawn and that's what ought to happen. No, the court is looking at what did the patient previously express. Number 3, is there a written advance directive? Number 4, and this is where a physician's clinical judgment comes into play, the nutrition and hydration will cause either one of 3 things: long-lasting, severe, and intractable pain. Number 2, it is not medically possible to give this person artificial nutrition and hydration. Or number 3, and again, this is in the reasonable medical judgment of the attending physician plus 1, the patient is chronically incompetent and in the final stage of terminal illness or injury, and death is imminent. Those are the only situations under which one can legally withdraw nutrition and hydration. Other instructions in the advance directive, again, there's basically a whole page of blank lines that you can give your specific instructions, and there's also a section regarding anatomical gifts. To revoke an advance directive, it can be revoked in whole or in part at any time or in any manner by the declarant without regard to the declarant's mental or physical condition. All they have to do is say they want to revoke it. It's effective upon communication to the attending or to any other healthcare provider. The authority of the proxy. The proxy becomes effective only when the physicians determine incapacity, and the proxy can only make life-sustaining treatment decisions following the wishes outlined in the advance directive. So insofar as life-sustaining treatment and nutrition and hydration are concerned, the proxy is bound to follow the wishes of the patient as they have been expressed to the proxy. I'm sure Mary will come back to this one, problems advance directives cannot solve. The Oklahoma DNR Act. A DNR order goes into effect immediately. As a consent, it can be signed by the patient or the proxy. If someone has a guardian, that guardian may sign it or a healthcare power of attorney. It's based on the knowledge of the person. The attending has to instruct the proxy that they are deciding, again, what the patient wants. A DNR can be physician-initiated if they know the wishes of the patient not to receive CPR, or in the reasonable medical judgment of the physician, it would not prevent the imminent death of the patient. Now here, on a DNR, the imminent death test, that is not a two-physician decision. That is the decision of the attending physician. But if we go back to the known wishes of the patient, the attending has to know by clear and convincing evidence. And that standard is a very high standard. Under Oklahoma law, it's defined as highly probable and free from serious doubt. This is way more than more likely than not. It has to be free from serious doubt that the wishes of the patient, when he was competent, were that he wanted a DNR order to be entered, or didn't want resuscitation. This is where the physician must encourage consultation between family, friends, and others with knowledge of the patient's desires. And only when the physician has reasonably determined that there's clear and convincing evidence that this is not what the patient wanted, can the physician go ahead and enter a DNR order. A DNR order may be revoked by the person merely by communicating. That can be oral, that can be written, or that can be just gesturing in some way to communicate to any healthcare provider. It does not have to be the attending physician. It can be anyone on the staff that they want to revoke it. If it's a representative wanting to revoke, they can do that orally to the attending. If it's to someone else on the staff, it has to be in writing. But that revocation, no matter how it's communicated, has to be communicated immediately to the attending if the person that initially gets the revocation is someone else on the staff. So you've got a DNR that's signed by the patient or the legal representative, either the patient or a power of attorney, healthcare proxy, or guardian. And when we talk about a power of attorney, keep in mind that that's not a financial power of attorney. It has to say that it gives the person, the surrogate, the power to make healthcare decisions, including life-sustaining treatment decisions. Or if you don't have a DNR consent, or there's not a representative, you can only make this declaration if there's clear and convincing evidence of the person's wishes, or CPR will not prevent imminent death. There's also a DNR compliance form that Mercy requires. It has to be completed. On behalf of the incapacitated patient, the physician has to make certain declarations and put it into the medical record, and then the legal representative has to confirm their status and acknowledge consultation with the physician. What if a patient does not name a proxy? And here's where the rubber meets the road, as I'm sure you already know. There's no law in Oklahoma outlining the hierarchy of decision makers if a patient is incapacitated and has left no instructions for end-of-life care. So once again, what we've just been talking about for the last 10 minutes is when a patient has left some kind of instructions, whether written or whether through conversations with friends, family, or with you, their physician. If they've left no instructions, if no one has any idea what they need, then there is no spouse or next of kin law allowing people to make those end-of-life decisions. So Mary is going to now talk to you about how you manage the risk in those situations.
Don't worry, we're going to leave you plenty of time to ask questions because this was a lot of information we were trying to get covered. I hope I got the list right.
So, what do you do when you don't have a decision maker? You have this wonderful physician here, Dr. Laura Cotton, who is the chair of your ethics committee, and you call for an ethics consult. Historically, we have seen that ethics consults are kind of when everything else has been exhausted and we'll finally call in ethics. And that's not what we want to propose. What we want to propose is how can ethics have a proactive and integrative role into the work that we're doing, which is part of why we're trying to come out and draw more attention to how we can be helpful. You have an excellent ethics committee who is doing ongoing education, who is keeping their ears open, trying to intervene when appropriate and when possible to identify situations that might get bad in the future. So there's essentially 3 reasons that we need to think about calling for an ethics consult. When we need clarification, when there's confusion, or lastly, if there's conflict. Ethics consults are important because they convey respect for persons and they create a space for voices and concerns to be shared in the pursuit of quality patient care and building an ethical culture. So one of my least favorite things is when I get on an elevator and someone says, "Ooh, your ethics. I'm glad I never have to talk to you." But I love when I get on the elevator and a nurse manager says, "Thanks so much for coming up. Thanks for helping that family out. They were really having a tough time. The nurses were really distressed by this." That's the kind of culture that we want to be able to create. And for persons who are in training, it's important that you feel like you have a voice that you can bring to other members of the medical staff. What we don't want to see happening is that people feel like they can't bring a concern forward because there's a senior member of that interdisciplinary team that doesn't want to call ethics. When that happens, you should automatically call ethics because there's something else in terms of space, power, and authority that is transpiring. So when we talk about clarification, it's talking about how do we apply these particular ethical principles? How do we think about treatment options, including no treatment at all? So my least favorite call is when I get something and say, the doctors don't want to do anything more, so can you justify that we take this patient off the vent, that we institute a DNR, that we transition to comfort measures? All of that is theoretically appropriate, but how we get to that space and time. So we don't wait till day 13 when we're trying to decide, should we trach and peg somebody by the 14th day? We should be talking at hours 12, 13, and 14. And if there's no family, we should be finding family. So in Oklahoma City, one of the processes that the social workers came up with is that after 24 hours, if there is no family there, they have created a protocol where they submit to me, and then I keep it in a folder that I submit quarterly to legal counsel, of how they will find family for an unbefriended person. And so whether it's using public databases, whether it's because you don't Google patients, right? You have all learned, we do not Google patients. But there are times where we need to be able to utilize those resources to find someone. And a few weeks ago, we had that. We had no family. We had no way of knowing. APS declined intervention of any kind, and it was a particularly vulnerable patient. So the person that I look up to the most is Nancy Drew. And I put on my little Nancy Drew, or perhaps Bess. I'm probably shaped more like Bess. But I went in and got on Facebook and started looking at who we had known had a relationship with this patient. And we found a friend who knew that this guy had been really sick, but he'd been trying to call him over and over again, and then just thought, well, maybe he, ran out of minutes on his phone, and that's why he wasn't answering. So I reached out to him through his work. I called his work, and I said, can you ask this gentleman to give me a call back? I'm the director of ethics at Mercy. And so he's all panicked, and he calls back, and I said, do you know a fellow by the name of? And he said, yeah. I said, tell me what he looks like. He told me what he looked like. I said, tell me what kind of tattoos he has. He told me what kind of tattoos he had. And I said, tell me how old he is, where how you know him. So we did all of this, and it turns out he was actually very good friends with this patient that no one knew that he was here. And so while legally he cannot be the sole decision maker for that patient, he can help us understand what would the patient have wanted. What resources did the patient have, and in this case, did not have. So instead of us making a unilateral decision, which is legally justifiable, how do we promote and protect the dignity of everyone involved? And how do we not put a poor attending in the the process of thinking, I have made this decision about this patient. Instead, how do we create a framework for making that decision? So usually when we're thinking about clarifying the ethics questions, sorry about that, guys. We want to think about what are the intrinsic values of what we're doing. Let me get back here. So the other issues are with regards to confusion. So what are the appropriate treatment goals? What is the course of treatment? So we all know that there are things that are clinically available. But when someone goes back to their community, will it be available? If they live in a rural community and they live down a dirt road and it takes them a couple hours to get up into the city, should we really send them home on outpatient dialysis? Should we send them home with an ostomy that there's no way they can pay for those supplies, and we know that we're going to put them in this really bad position? We have an obligation to inform them of that. And then we have conflict. When you use the word futile, you automatically set yourselves up for conflict with family. That is the line in the sand. But even if you edge up to that and say, well, the clinical team doesn't think. So we had an experience just last week where we had an all-white clinical team and a Native American family. And the next thing you know, the family has asked, can they bring in some folk medicine? And our all-white clinical team says they want to do something different. And I'm slightly exaggerating. Martha can give you the real details, but this is a teaching moment. But at one point, Martha, they did use the words Western medicine and Native medicine. And so what is our responsibility at that point? So we go in and we meet with this family, and so we're trying to ask real sensitive questions and saying, you know, is there anything in this salve you want to put on the patient that could cause an allergic reaction? And the son of the patient said, no, it can't, because it's the medicine she needs. He could not conceive, based on his anthropology, that there could be a conflict between what we were providing for the patient and what a medicine man could provide. But all of you are walking through your chemistry brains, thinking about your classes in pharmacotherapy and thinking there are times when certain drugs interact with certain things, and that's why we have allergic reactions. But he rejected that claim outright. So we could have in good faith said, we don't know what's in that salve. We don't want to be responsible to mitigate that risk. We will not allow it. How well do you think that would have gone over with this family, with this all-white clinical team? Chaplain Steve was there, and he was like, it would not have gone over very well, because what they did is they went to Martha, and they waved the patient bill of rights in front of her and said, I have the right to culturally competent care. And they were right. But we had to get there in a way that navigated that particular space and time. What I encourage you to think about is the idea of best available care. That care is clinically indicated, that it's clinically appropriate, and it advances the patient to the next level. If it is simply prolonging the inevitable, that is not the best available appropriate care. It has a demonstrable benefit. It does not result in excessive burden, and that includes financial burden. And it's actually available with qualified staff. Can we actually do what we are proposing to do? The other caution I have is about quality of life. So there is a law now in Oklahoma that is called the Non-Discrimination in Treatment Act, and it says that we cannot discriminate based on age, disability, or quality of life. So if you go to a patient and you say they have bad quality of life, that's why we're taking them off the vent. That family, that legal representative, has the right to seek injunctive relief, to call a timeout, and then to pursue, perhaps, the treatment that they so desire. You are not, however, obligated based on your own conscience and based on your practice to provide care that you know will hurt a patient. So to avoid all of that, don't say that grandma's old and she's lived a really good life, and someone younger could benefit from that treatment. Because that is, in fact, an exact line that I've had from a physician. Wouldn't you rather that someone younger get these medical dollars that we're spending? Or if someone has Down syndrome or has some sort of congenital birth defect, what does that mean for them? That is their disability. But is it a disability? It's just different. And so how we have to frame and reference that is increasingly important. So essentially, all advanced care planning documents do not substitute for your ability to have good conversations with your patients, their families, their legal representatives. You need to understand what your responsibilities are with regards to end-of-life care, and you need to know how to access your ethics consult resource. Susan and I are going to be here for at least 15 minutes, and we'd like to open the floor to questions. Please. Chaplain Steve. Yes. Yes, that is really important. And Martha can help you all because there is your all's policy now is more congruent with Oklahoma law. And there are forms, and Martha can get them, sorry, I'm like volunteering you for things, can get you these forms so that if you have a family member who's there and says, no, I remember we were sitting around, it was Thanksgiving, and Grandma told me after we watched an episode of ER, she never wanted that to happen. How do you translate that as a physician into those other two standards of either the death is imminent or clear and convincing evidence? We've actually given you space on that form so that if you want to write in what in fact is your clear and convincing evidence, you are not compelled to do so, but we have that in there just, if it makes you feel better that you are writing down that you didn't unilaterally make the decision. But if you have a family member there, you don't turn to them and say, oh, by the way, you're my sister, can you just sign this? My sister does, in fact, happen to be my healthcare proxy, but my other sister is not. So it would not be appropriate for whoever's available to sign that form. Sure. Yeah. And so the DNR, just to be clear, in Oklahoma is either full code or no code. And the medical staff has requested that in-house there's some other options. That's aside from this talk, and Martha's going to do that education for you all. What other questions? Yes, ma'am. Yeah. So there's also another line in there about nutrition and hydration that says that my proxy must make decisions as I have put forth or as I have put forth with the exception of nutrition and hydration. And so that is an important clause to read on what that says. So a lot of times proxies think that they have much more authority than what they do. For the most part, someone is saying, I want you to be my voice. I have this piece of paper, and you are my verbal voice with this piece of paper to the clinical team. And I think to avoid the conflict is you just kind of say, it's really interesting that these were the wishes that your sister, your friend, your mom put forth. Kind of what was going on in her life. So it's redirecting, still getting to the same place, but it's not saying, well, no, you have to. You are legally obligated to follow what this person put forth. I mean, once you say you're legally obligated to do anything, it's as good as just saying, I'm done with you. I don't want to have a conversation. And we are on separate sides. and you need to be negotiating to ease yourself onto the same side as that family member. Because that family member wants to trust you. They want to be part of this, but they also know they have this responsibility. You will inevitably get that strange family member who you think they're trying to keep somebody alive for Social Security or for whatever small monetary amount there is. It's very rarely ever the case, and again, it's such a small amount of money that it's negligible. But sometimes we get that in our head that they're not making a good decision because of these other external forces. So I think just navigating that. If you feel like you can't have that conversation and you feel like you're getting frustrated, you need to step away from the conversation. You need to get somebody like Chaplain Steve, or you need to get your bedside nurse involved so that you don't lose that trust with that patient or their surrogate. Because once you lose it, it's just going to be an acrimonious relationship, and it's going to be the worst week of your service, and then you're going to be a week off, and then you're going to be a week on, and that patient's still going to be here, and then we're going to be 32 days out, and finally Dr. Cotton gets a phone call. Ethics consults should not be happening 32 days after admission. They should be happening 36 hours, because you know, if you've already been testing the waters and you know that family is ticked off, just ask for help. It is a 24/7 resource. I can be here, Dr. Cotton can be here, Dr. Cook has been volunteered last week significantly to be here, so, you know, and you got all sorts of folks. Steve, you look like you're... A power of attorney and a healthcare proxy. So Susan made a point about this as well. So if someone will show up and they'll say, my mom, you know, she told me I'm in charge of all of her accounts. And so you look down, and it's usually like the point 13 or 14 in like a 27 bullet point document, and it'll say usually something like to provide placement and medical care for the patient. So that really means that you will pay the bills at the nursing home. It has to have that clause in there that they can make medical decisions, including decisions about life-sustaining treatment. So sometimes we just are sloppy in our language and we use durable power of attorney. So someone may also have a financial durable power of attorney. Or a parent may trust one kid with money and another kid with their life. And you just, that also is going to create conflict. You know, those two siblings are going to have that. But when that happens, just call for help and we can review that document with you and figure out what we need to do next. Incapacitated. Mm-hmm. It's not really, it's still incapacitated immediately.
Right,
It says that, but it doesn't, this has happened before, yeah.
under Oklahoma law, a durable power of attorney has to meet the same requirements as a healthcare proxy in order for it to function as a healthcare proxy. Otherwise, they can make medical decisions sort of up to life-sustaining treatment and nutrition and hydration. But when you get into this area that's otherwise within the authority of a healthcare proxy, you've got to make sure that the power of attorney meets all the requirements of a healthcare proxy, and then it's going to kick in the same way a healthcare proxy.
So sometimes it's like when people have early onset of dementia and they probably couldn't remember to take their medications or go to the doctor, that part of helping to make medical decisions could be effective immediately. But it still is the two physicians have to say, you are chronically incapacitated. And now this person is making decisions with regards to life-sustaining treatment.
Right, because your illness has become terminal, or because you're in an end-stage condition, or
Persistently unconscious.
persistent.
I also want to make a clarifying remark about nutrition and hydration, and this is why I asked Susan to do the slide. That law is more narrow than the Catholic directives. Because one of the questions when I first came out here was, Mercy's going to make everybody have a PEG tube. And that is not correct. So there's a presumption in favor of nutrition and hydration if it is of sufficient benefit. So those just bad enough strokes, that person's not going to die from that stroke. but they might die because they aren't getting nutrition and hydration. Under Oklahoma law and the directives, we have an obligation to discuss the feeding options. So my normal frame of reference is, if someone wants to go on inpatient hospice and they're not going to meet their maker in the next 2 weeks, then we need to really be thinking about a feeding plan.
Well, and another thing I want to point out, Mary, is that even if they have instructed the withdrawal of artificial nutrition and hydration, the law requires that they still get oral food and water to the extent that they are able to take it, and medication or treatment for pain.
Right, and that is Oklahoma law, okay? Just to be really clear, because that was an issue when we came on board. What other questions? Yes, sir.
So I have a random question. Happened to us here at the hospital here. We had incapacitated patient, and essentially only local family member was, he was deemed by some other physician, he was mildly mentally retarded, had a live-in spouse or a live-in girlfriend who said, well, I'm common law. Other family members haven't seen in 5, 10 years, live in Chicago. Who do you follow? Do the physicians then say, we're going to take control of the healthcare when the patient has a condition that cannot be reversed? Or do you listen to the common law? What makes common law?
So I'm not going to speak anything about common law, and I'm not going to make Susan do anything about that, because that's why we had the slide. There is no hierarchy about next of kin. So however they file their taxes, that is how they file their taxes. But this is one of those times where you, as a physician, have the responsibility for that best interest. So you know how the Hippocratic Oath actually says, first do no harm? Our ask of you is to first do good. So if you have a family, so sometimes we choose the path of least resistance. Whichever family member agrees with us, we justify it to ourselves and say, yeah, that seems really reasonable. That's the best interest standard. But sometimes you have to live with the discomfort. Now, just because someone has a mild intellectual disability doesn't mean that they cannot say, this is how my sibling would or would not have wanted to live, or they could be estranged. It is always better to find the people who are most closely intimated with that patient than some random estranged family member who hasn't talked to them in years. So I even had a healthcare proxy this week who hasn't talked to this guy in a month. He talked to him in a month, but before that hasn't seen him in years. But he got named this guy's healthcare proxy. So we call him and say, you've been named the healthcare proxy. And he's like, I don't know how to make decisions. And we said, we'll help you. That's our responsibility. But how do we have that shared decision-making approach? Now, you can designate someone the family spokesperson, that you call one person, and you have an expectation that they will inform everyone else. And you do that until you find out from nursing staff that they're never calling the other people, and the nurses are getting called 800 times. So you may have this good relationship with that family, but be kind and think about what your nurse is having to deal with, or your case manager, as part of this interdisciplinary team. But it is, how do you bring folks together? Dr. Cotton has an iPad that we have a teleethics capabilities with that. We can get you Skype accounts, so if you want to bring other family members in so that we can have conversations, but weigh it against that prudent patient standard. In a typical situation, what would a typical patient choose or not choose? And write that out. And then bring that forward and say, you know what, this family is asking for the moon, and I can only give them the North Star. What other questions? We are at 8, but we can stick around and answer sidebar questions. I really appreciate your time and attention, and again, appreciate the invitation. And my contact information's up here. Dr. Cotton has it. We can get it for you. Susan's as well. Thank you all.
Oh, yeah, I will come in. So, thank you. Appreciate it. No, that one was in there.
Oh, okay.
Thank you.
Oh, you're welcome. Thank you.
Thank you.